Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's go to, the opposite of race, interestingly, or the opposite of race issue is a issue that's not based on race. So let's go to Hartford, Connecticut. And here the city was successful defending a race discrimination allegation lawsuit. And the reason they were successful is really important for the viewers because there was all sorts of claims by the firefighter that I was denied leave and I was drug tested and I was treated differently than than white people in the same position. And the court looked at it and really said, you know what? You haven't linked your race. And there's two reasons I think he lost, in my opinion. One, the court says you haven't linked your race to the reasons that you were treated this way. In fact, it seemed like you were a problem, which is, I think, what the court finds. There is actually a legitimate reason. That's the second part. There's a legitimate reason why these actions were taken against you. They weren't based on race, but nonetheless, he didn't even prove that race was a factor. And they go through his, 10 some odd allegations of when he was treated differently and, and not in a good way, I guess, not promoted, not given leave, all these things, drug tested. But the court just says, you haven't shown that race was a factor. And in fact, it seems like they had a good reason to do it. And so, for people out there who think, oh, I'm just going to claim the race card, religion card, any card, right? Any protected class card, you better be able to prove that the reason they're doing something, one, is based on your protected class, and two, that there's not a legitimate reason they're doing this, which has nothing to do with your protected class.
Yeah.
So
I think I covered him his earlier allegations in the same case when they were dismissed, and the court kind of gave him a second shot at amending his complaint here, but essentially the facts that were alleged were not sufficient. They were, I think, I want to find the right way the court phrased it, but they were more about, personality conflicts and the types of things that happen in the workplace as opposed to race discrimination. So you can't find the exact language right there.
Well, yeah, and he says he couldn't prove a discernible connection to his race. And,
right.
You have to. And normally the way they would do that, by the way, is say, well, okay, we have one black person who was treated negatively. We have 10 white people who did the same thing, but they weren't treated like the black person, right? And so that would be a way to show it. He couldn't even do that. So had he done that, the burden then would have shifted right back to the employer to prove that there was a legitimate reason that was free in any way of his protected class, in this case, race.
Here's one of the quotes. The law does not blindly ascribe to race all personal conflicts between individuals of different races, because to do so would turn the workplace into a litigious cauldron of racial suspicion. Okay. Yeah. So interesting quote there.
I phrase it differently, and I've always said this, being a jerk is not a protected class, and we could fire you because you're a jerk, right? Yeah. You may be a black jerk, gay jerk, Jewish jerk, whatever jerk, or woman jerk, right? But you're just a jerk, and that's the reason we're firing you. So that's not.
I don't know if that's the case with this particular guy.
I'm not saying that. I'm just saying
right. Right. No, I agree with you. But the court. The court is essentially saying that if you're going to say that someone discriminated against you because they yelled at you, you've got to show somehow that it was racial and not for some other reason. Not because, for example, you were about to run somebody over by backing up without having a spotter and they yelled at you. They yelled at you because you were backing up without a spotter, not because because of your race or your religion, or
unless they scream, hey, you effing whatever, right? Slurs, that might do it.
Right. Or someone who was not in your protected class did the exact same thing and didn't get yelled at. So that's right. And I think that's the point that the court was trying to encourage the person, the firefighter, to point out, but it never materialized.